Simon Makwaba beyond the bar channel so. Now say the better manum can say a year and then a Supreme Court after say a year NDP NDC now be ambra a year Supreme Court. Now High Court and some higher court so say a year regulation and my EC a regulation NDC for so Montias and then a court my quan say Ubi ambra no can ask some court no and send be a few court over many shame court and some more kind and some ambition will be about in evidence Abama. And same be a court, so our court to honor and send the baby Tiabe court. Ya kwakuti a year and some higher court so Supreme Court. Wabra NDC day and some copy court say High Court I make some judgment to be on Montia Sentinel on what they call Supreme Court, not in Chichin where they am almost said High Court judgment or passing and say no crime and say no crime. Tiabe court near Kwakuti and some can free. Supreme Court to Eba wa brand MPP NDC and easy or more Supreme Court. Young Corny and Kutia
ACAON Yes, applicants. We have a preliminary legal objection to the propriety of the application. I will pray that we take out my first. Since we don't file it, give us an idea so that we'll see whether we want to put down formally. This application was mounted on Rule 61. 1. Of CR 19 as amended by CR 124. CR 16 more of 124. And the laws, this was for signature. The applicant is mandated. To file the decision. With application it's mandated. So with a decision. Yes, any second ground. This is a point you have made which is well known. The rule says so. And they did not file that's right. A decision. Okay. In the case of I say yes, that's the ground. No, I think having regard to this is a matter that we have. If the decision is available, we normally prefer to determine it on the merits. See the decision is before the court, or we determine the application on the merits, having regard to the nature of the case. So, I think, if you don't want to drag on matters which are trite, you have a point, you have made it, but the court has, you have mentioned non-compliance with the rule. Yes. And the court has power to waive it. And the court has waived it and said, since the decision is before the court, let's hear the application on the merits. And you have done it. You have argued on the merits. Well, at this point, the decision is the best way to help you. Yes, what happens? And this court made a decision on which of the and indicated that you cannot move fast or put it. You cannot find it. You cannot exhibit it. You cannot find it. You cannot find it. No loss. It is here. This is here. Counsel, you have pointed out non-compliance. We have waived it because the decision is before the court. We want to hear the application on the merits. Yes, applicants. My lords, we have before you an application invoking the supervisory jurisdiction of this court. My lords,
yeah, our recording system is working, so we don't have to write everything verbatim.
great. My lords, I move in terms of the motion paper, the grounds set out in the motion paper, the affidavit in support, yes, my lord, the supplementary affidavit in support, the statement of case and the exhibits annexed to the application. My lords, our ground for this application is that the order made the orders made by the High Court were made in breach of the applicant's rights to be heard. My lord, the further ground is that the trial judge demonstrated apparent bias and partiality. 3, that there was a non-jurisdictional error of law by failing to exercise the court's powers under Order 55, Rule 5(2) of CI 47 to direct 2nd to 6th interested parties to serve the mandamus application on the applicants who have interest in the subject of the dispute. And finally, error of law apparent on the face of the record, which error of law occasioned a substantial miscarriage of justice to the applicants. My lords, I wish to draw this honorable court's attention to exhibit to exhibit 5 series. Sorry. My lord, a brief fact I think will be important in this matter. My lord, an application for mandamus was filed before July Jurisdiction 13. Now, at the hearing of the said application, after counsel for the applicant and the respondent announced themselves, I drew the court's attention to a joinder application. The trial judge, the trial judge requested I show him a copy of the joinder application. He therefore asked his clerk, a lady clerk, to come for a copy of the joinder application, looked at it, and proceeded to write his ruling. My lord, the ruling we have exhibited to the supplement, the supplementary affidavit, as the B series. My lord, in exhibit B1, the trial judge clearly indicates And my Lord, with your permission, I just want to read the portion. Page 2 of the ruling. So, therefore, the gender application notwithstanding, it is not safe, and offense will 20.
Now help us, which of the applicants ruling are you reading?
My Lord, with respect, that's...
One actually is, the rulings are exhibited as Exhibit A.
Yes. But in the supplement, it comes as Exhibit B series.
Okay. I have it as
in the supplement.
Okay. Now, which applicants ruling are you talking about?
This is... My Lord, this is the fourth applicant's.
Now we have Nana Ekuya Olusa Free. We have
the one I have with me is that of fourth applicant.
Mention the name.
I'm an Ope Philibert.
Okay. There's Patrick Yabuama.
That is so, my Lord.
There is James Akosa.
But this one is Expertise Frank Amo Dompre.
This what we
know very well.
Because that makes it easier for us.
B1.
Anyway, once you get the name of the applicants,
Expertise Frank Amo Dompre. Page 2 of the expertise and not on prayer.
that's one of there's so many problems.
So, my Lord, with respect, exhibit B2.
Okay.
Expertise Yao.
Which one are you reading from?
So, my Lord, I wanted to read Expertise Frank Anobompre, page 2
yes.
of the ruling.
Yes. So now we are on the same page. Yeah.
Yes. So the verse says, therefore, the gender application notwithstanding, it is not said an offense of adulterating Rule 40. The application is granted as prayed, and the respondent hereby is ordered to collate and declare the winners of this election. So it proceeds. Yeah. Now once again, in exhibit B2, Expertise Patrick Yabuama.
Yes.
At the same page 2. Quote, therefore the gender application notwithstanding, since it is not said an offense will 20, the application is hereby granted.
Yes.
Exhibit B3.
Now, so your point is,
the point we are making is that at all material time, the fact that was before my Lord was that the applicants herein, whose interest will be affected by that decision, ought to be heard. And that failure to afford them a hearing before the decision was given offends the order authoring party rule. And that offense cannot be cured and should result in the invalidation of the decision by the trial judge. My Lord,
Professor,
yes.
So you will hinge it on the application for joinder. Failure to grant you a hearing is anchored in your application for joinder.
Yes, my Lord.
Is that the case?
No, my Lord. First of all, my Lord, I just want to draw the court's attention to this. Order 55.
Yes.
6-2.
Well, let's look at the issue of joinder first.
Okay.
Yes. So as far as the failure, alleged failure on the part of the trial judge to hear you, your case is anchored in the application for joinder, whether partly or wholly.
No, my lord, maybe partly.
Alright.
Even without the joinder, with respect, even without the joinder, by reason of the provisions of Order 55, 6, 5, 2, it says that a notice of application shall be served on all parties named in the applicant's affidavit as being directly affected by it. 2. The court may order that the notice of the application shall be served on any person not named as being directly affected by the application if in his opinion it desirable so to do.
So that is the 55 prescription.
That is 55 prescriptions.
And you mentioned the joinder application, so I'll bring you back. Now, the application for joinder was based on Order 4. Was that the case?
That is correct.
If you have your rules, will you look at Order 4, Rule 5? Order 4, Rule 5, Sub-Rule 5. You may start from Order 4, Rule 5, Sub-Rule 3. The provisions there indicate what must be done when the court decides to grant an application. Can you read 4 Rule 5.5?
It says when an order is made under Sub-Rule 2, the writ shall within 14 days after the making of the order or any such period as may be specified in the order be amended accordingly. And in terms with the reference to the order, in persons of which the amendment is made and with the date on which the order for the amendment is made.
So it talks about a writ.
That is correct.
Yes. Turn to Order 82. A writ has been defined as a writ. I think it's the very last word under the interpretation section. What does it say?
My Lord, it says a writ includes a writ of summons, statement of claim, or a petition in a court or matter.
So it doesn't include the application before the trial judge.
My Lord, it's an originating process.
Yes, but it's not a writ.
You see, my Lord, the word uses includes.
Now, would you say that the provisions in Order 55 are cognizable to the joinder and Order 4?
My Lord, the provisions of Order 55,
yes. Because by your own showing, Order 55 has prescribed means by which the court can hear a party whose interest will be affected. You understand? By service of the affidavit. So would you say that that provision, an application under Order 55, will recognize a joinder application under Order 4?
No, it should. And my Lord, the reason is that, my Lord, with respect, the reason is that the rules of joinder,
Yes.
unless there is a specific provision detailing how an originating process should be done differently other than Order 4 is applicable. And my Lord, if you look at the reasoning of the trial judge,
Yes.
he did not reason that the application was brought persons to Order 4, for which reason he was not going to hear it.
Having said that,
So I'm going to say that.
So whether given that Order 55 has prescribed means by which the court may hear a party whose interests will be affected, there is a need to even call in Order 4, and whether Order 4 has other basis in the judicial review application.
We notice that the issue of natural justice is a constitutional matter. And the rule cannot, as it were, defeat the intent of the Constitution. That to the extent that a person will be affected by a judicial decision, that person ought to be heard, with or without the rule. And so the issue of the rule coming in aid with the greatest respect does not even arise. We are raising a fundamental question that relates to the rules of natural justice. It cannot be said that Order 4 or any other rule, if not complied with, satisfy the requirement of hearing. It cannot be the case, to the greatest respect. 2,